on to the grounds now. If we're looking for a reform agenda, then it seems to me we would be aiming for all areas of public life without specifying any particular area of public life, rather than, education, services, goods, facilities and so on, but all areas of public life. If that's not possible, then there are two particular issues that I'd like to draw out from a disability perspective, not that they're unique to a disability perspective, is that I think an equality bill ought to specify government functions as distinct from, in some cases, services as being a ground that is covered. For those of you that might not appreciate the point I'm making, often police, for example, and law enforcement activities regarded by the courts and tribunals as being functions of government that are not services and are therefore not susceptible to attack from a discrimination perspective. The law is more complicated than that, but there have been some very unfortunate cases where police have been said to fall outside a discrimination regime. And whether you're coming at this from a victim's perspective or for people who disproportionately are subject to police intervention, it seems to me to be a key area that needs to be certainly covered by discrimination law, and government functions might be one way of doing that. The other area that I think is very important from a disability perspective, and it echoes Lez's point from a race perspective, is bias crime, in particular vilification, but not limited to disability vilification. We would certainly want to see a national equality bill deal with that. And moving quickly then into the next area, I want to make a couple of comments about enforcement. Where I think it's very, very important that we adopt, in effect, a fair work model for the enforcement of discrimination laws in Australia. That is, we should have an ombudsman to whom complaints can be made, as well as the ability to make individual complaints to the Commission and ultimately to the Federal Court. But there needs to be an agency with a function and a power to investigate claims of discrimination and to prosecute those claims in court in circumstances where that's appropriate. The private litigation model of discrimination works for some people, but it most particularly does not work for the most disadvantaged people. There needs to be a public agency that has responsibility to pursue that in the public interest. Similarly, in relation to the existing criminal offences, those being victimisation and incitement of discrimination, but if Les and I get our way and there are vilification provisions included in a new act, which might have a serious vilification being a crime, there needs to be a joint investigation function specified in the legislation that requires both the Human Rights Commission or the Ombudsman that I've put up and the police to be responsible for the investigations of those crimes. In effect, even though we have criminal offences in discrimination legislation at the moment, there is no rationale or means or pathway by which those criminal offences can be complained about and investigated and prosecuted. In effect, they're just a few words on a bit of paper. We need actually a theory for how those criminal offences would in fact be investigated and prosecuted. Jumping now to the issue of exceptions, which I think is an area that probably needs a bit more consideration in this forum. Again, we're hoping for a rounding up so that there are very few exceptions to discrimination law in general, and the Disability Discrimination Act is one of those acts that potentially benefits from a rounding up to the Race Discrimination Act. One of the big issues is, of course, organisations of religion and faith, and there are some disastrous decisions around the country in this area. It seems to me if there's going to be an exemption for religious organisations, which we may have to face is unavoidable, we should attempt to import from the Victorian Charter the functional public authority model. And for those of you that aren't familiar with that, basically what the Charter prescribes are types of public authority. There's the core public authorities, which we understand to be a government and its instrumentalities. And then there are functional public authorities, being those agencies that receive government funding to provide government services. So, for example, Wesley Mission, which is an agency that was found by the New South Wales Administrative Decisions Tribunal ultimately to be able to discriminate against same-sex couples because of its religious, it fell within the religious exemption, even though it received public money from the state government to provide fostering services. Now, if you were adopting a functional public authority model, that would be an agency performing a function of government and would not be exempt from discrimination legislation. So I think that's quite an important issue for us to pursue in this context. Moving quickly now to defences, it seems to me that one of the other things that we should really be trying to draw into an equality bill from human rights law and including the Charter is a much more sophisticated proportionality test than currently applies in discrimination cases. Often the question before the court or the tribunal is, did discrimination occur or not? And it's a very black and white kind of analysis. What we need is a more nuanced interrogation of whether the respondent's conduct was appropriate in the circumstances, and a proportionality test, which I won't have time to go into, like that that's included in the Charter, would require a respondent to provide a much more sophisticated justification for why it acted in a particular way, rather than just being able to show in a black and white way, well, you haven't met the bar in this particular case. And I think there should be a further amendment that says that it's simply not sufficient for a respondent to show as a defence to discrimination that it owed a duty to another person. Now, I don't have time to go into that, but often an educational authority will say, for example, in relation to a claim of indirect discrimination brought on behalf of a student with challenging behaviour, oh, well, we had to look after the other kids. Well, of course they do, but that shouldn't be the end of the analysis. To merely state that a duty is owed to another person shouldn't be permitted to be a defence to discrimination, and the courts often allow it to be. Finally, on access to justice, I just reiterate, I'm sorry, I don't know your name, but in the front row, the issue of the cost jurisdiction is incredibly important from a disability perspective, and I'd also like to hook that back into the issue of damages. For example, I have a client at the moment who's pursuing a claim against an airline. I gave this example yesterday, where if she pursues that to the ultimate, she may well lose her case given the mean nature of Australian discrimination laws. When they're before the court, she may win, of course. She's going to expose herself to tens of thousands and perhaps even more than $100,000 worth of damages if she loses the case. There is no economic loss involved in her claim, so she'll be claiming for hurt, distress and humiliation, and if she's before a very sympathetic judge, she might get $10,000 to $15,000. Now that just, I think, shows that the incredible imbalance between what one has to do to enforce a discrimination claim and what one might get as a result of that effort. So clearly there needs to be some action around the issue of costs, and in my view there also needs to be some action around the issue of damages that are awarded in discrimination claims.
Two quick observations about Philip's presentation. One is that without dogging in, I can see the Attorney General's consolidation team furiously taking notes. Quite a manifesto. Oh, thank you. And the other was just something I picked up at the beginning before Philip very powerfully got into the detailed legislation. That is a connection, both Les and Philip, connecting discrimination legislation with international conventions, which remarkably is something fairly new in the jurisdiction, to actually be explicit about the treaty origins. There probably weren't origins, but what we can now say are the treaty origins of our discrimination legislation, and perhaps a greater focus on that, looking at CERD and the CRPD. Any questions or comments for Philip? Oh, the other thing I was going to say was, he said lots of things that would have given you reason to stick your hand up.